In May 2011, Dr. Michael McDonald entered a Seattle clinic, his hip radiating a deep, systemic agony. An academic with severe osteoarthritis, McDonald had undergone a high-tech hip replacement just 1 year prior. He sought a return to mobility. Instead, he was being slowly poisoned from the inside out. During the initial surgery, Dr. Joshua Carruthers made a high-pressure, intra-operative pivot. He chose the Zimmer MLTK dual modular system, lured by the promise of perfect anatomical flexibility. This choice would lead to the landmark case, McDonald versus Zimmer, Incorporated. The claim: strict liability for a design defect that rendered the implant unreasonably dangerous. In October 2011, Dr. Christopher Beauchamp performed a revision surgery at the Mayo Clinic. He didn't find clear fluid. He found a turbid, cloudy reservoir of metal debris and necrotizing flesh. A pseudo-tumor had formed, killed by the constant shedding of cobalt and chromium from the modular junctions. The legal battle centered on whether the device was unreasonably dangerous under New Mexico law. Zimmer argued the device was unavoidably unsafe, shielding them from strict liability because of its unique benefits. Plaintiff's counsel exposed Zimmer's fragmented testing. They tested the components, but never the full assembly. Internal Project G2 files showed Zimmer knew the dual modular design increased the risk of fretting corrosion. Blood tests proved the result. McDonald's cobalt levels were 10 times the normal limit. Presiding over a bench trial, Judge Nan G. Nash rejected Zimmer's unavoidably unsafe defense. She found the risks outweighed the benefits, especially since safer, single modular alternatives were readily available. The court found Zimmer strictly liable. The design itself was the defect. The Court of Appeals affirmed, ruling that manufacturers cannot hide behind comment K when their testing is incomplete. For Dr. McDonald, the win brought justice, but the systemic metal toxicity remains a lifelong burden. The practice takeaway is clear. In medical device litigation, the goldmine is often what the manufacturer failed to test. Always subpoena the specific corrosion fatigue data for the exact assembly used by your client, not just the individual parts. If the manufacturer gamed their own safety standards by testing in isolation, they've handed you the case on a silver platter.